Good afternoon to everyone on the East Coast and good morning to the rest of the country. My name is Mark Newberger. I'm of counsel in the Miami office of Foley and Lardner, and welcome to our presentation today, how the Supreme Court's affirmative action in education decision will affect employers' DEI efforts. To take us through this process, we have an exciting panel of speakers. My colleagues in labor and employment, starting off with Mary C. Cravato, we call her MC. She's based in our Orlando office. Dan Kaplan, a partner in our Madison, Wisconsin office, and Sarah Madavo, partner in our New York City office, who's coming live from the West Coast of the U.S. today. So with that, I'd like to walk you through our agenda for today's program. We want to start off by giving you a historical review of some of the Supreme Court's affirmative action decisions prior to the most recent ones, then go through what the court did in the combined cases of student fair admissions versus Harvard and the University of North Carolina. We then want to talk about, because those were educational affirmative action programs, college admissions, we want to talk about what signals we see and what we think it means for employers' DEI efforts, and then what we can expect in the way of future lawsuits. We've already seen some, and we're going to talk about those. Finally, wrap up with learning points on what employers can and should be doing to preserve their DEI efforts and avoid them becoming the targets of litigation. And so with that, I'm going to turn it over to our first speaker. MC, take it away.
Great, thanks, Mark. So as Mark just went through, we'll spend the majority of our time together today talking about the impact of these decisions, right? How they impact you, your companies, your businesses, the real practical effects. I know that's why you all are here. But we would be remiss to not spend a little bit of time unpacking the actual holdings, the actual language in the recent decisions, and the history that got us there, right? The history of educational affirmative action programs in the country. As you'll hear, there are a lot of open questions remaining, right? We're all kind of in this figuring it out together. So it's really more critical than ever to go back to the actual language of the decisions and to the history to better understand where we're going in the future. So when we talk about affirmative action in the educational setting, we're referring generally to a practice or policy of specifically favoring individuals belonging to one or multiple groups that have been historically regarded as disadvantaged or subject to some type of discrimination. And we really find the roots of affirmative action in a little case that I'm sure you are all familiar with, Brown v. Board of Education. That was the landmark 1954 case where the Supreme Court held that separate is not equal, effectively banning segregation in schools and practically, hopefully, leading to the integration of schools across the country. Now, I think as we probably all know, the sort of path from Brown to full integration was not necessarily a smooth one, right? And many sort of academics, activists throughout the country were just quite frankly unhappy with how little integration was actually happening in America, even though it had been essentially decreed by court ruling. And one such educational institution was University of California, Davis. A little bit of context, it's interesting here. UC Davis was established in 1968, and the medical school in particular. So we're talking, a decade after Brown. And the inaugural class was all white, despite the fact that integration was mandated. So the folks at the school felt very strongly that some type of specific preference, right? Some type of preferential treatment needed to be given to African-American applicants, given the sort of the history of discrimination and really, underprivileged of issues that African-Americans had faced in the country up to that date in admissions decisions. And so what UC Davis did is they specifically developed a quota system where they held, initially it was 8 seats, and over the years that number rose, but a certain number of seats in each class that they held specifically for minority applicants. And sort of not surprisingly, given the history here, an individual, Bakke, he challenged this decision. He sought application. He was denied admission. And eventually his case, made its way to the Supreme Court. And SCOTUS in 1978 held that quota systems like the one implemented by UC Berkeley were unconstitutional as a matter of law and violated the Equal Protection Clause of the 14th Amendment. And without turning this into too much of a con law seminar, the Equal Protection Clause really requires at a high level government actors to show a compelling interest for any race-based classification, and then to also demonstrate that whatever sort of the challenge policy is narrowly tailored to achieve this compelling interest. So Bakke, the court says you cannot use a quota, that's unconstitutional, but you can consider race, right, as one factor among many in making an admissions decisions. Fast forward to 2003, another major decision makes its way to the court. This was a decision involving University of Michigan Law School, who used affirmative action principles in their admissions policies and procedures with the specific aim of achieving what they called a critical mass of minorities in employment. And the university said that its compelling interests, if you will, underlying these policies were to ensure that minority students felt well represented, felt that they had a voice on campus, etc. In a majority decision by Justice O'Connor in 2003 in this case, she held that was constitutional, that these were interests that were compelling, and that the way that the school had sort of fashioned its policy, it was narrowly tailored enough, that there were no issues under the Equal Protection Clause. But there were a couple of caveats. Some might say these are holdings, some might say they were dicta, but a couple of issues that the court raised moving forward. First, the court said that educational institutions can't use race in a way that leads to negative stereotyping. So assuming all individuals of a given minority think or feel the same way by virtue of their minority classification. Second, the court said that educational institutions can't use race as a negative to other non-minority groups. And third, the court noted its hope or its thought that 25 years from now, it would no longer be necessary to consider race, in any sort of shape or fashion in education admissions. So that leads us to today, right? We've got these two highly anticipated big rulings that represent the biggest shakeup in the affirmative action space, really since, Bakke in 1978. I won't get too into the specific policies that were an issue in these two cases, but at a high level, they both involved admissions in which race was a preferential factor, right? So applicants were either assigned points based on their race, the institutions considered the racial makeup of their admissions class as a whole in making final decisions, things of that nature. And in the majority opinion, which was written by Chief Justice John Roberts, the court found that the policies at issue violated the Equal Protection Clause of the 14th Amendment. And again, I'll try not to be too con law professor on you all, but there's two important things to break down from this decision. First, the court held that the compelling interests that had been advanced by the educational institutions in support of these programs could not be subject to judicial review because, in the court's view, these interests were immeasurable. And some of the different interests that the universities had put forth were things like training future leaders, acquiring knowledge based on diverse outlooks, promoting a robust marketplace of ideas, creating engaged citizens, in the world, that sort of thing. So we were dealing with slightly differently articulated interests that those that were at issue in sort of the other cases back in 2003, right? But these particular interests, the court found were not measurable, sort of, in the court's view, lofty ideas with no real tie to anything. And then second, the court found that the admissions programs did not actually have a sufficient narrowly tailored connection between these goals and the means the admissions policies employed to hypothetically effectuate these goals. Again, the court found that some of the racial categories used in these particular admissions programs were In some cases, overly broad. So for example, grouping all Asian applicants together instead of separating them out into East Asian, South Asian. In other cases were somewhat arbitrary or undefined, so loosely referring to all Hispanic individuals as sort of one big group without further delineating important differences. And then finally, that some of the categories used were under-inclusive and that certain minority groups, for example, individuals of Middle Eastern descent, were not able to sort of adequately express their background in a way that had any effect on their admissions process. And interestingly, the court attempted to distinguish itself from Grutter. In the majority's view, it did not overrule Grutter, but instead clarified. This is, of course, what the majority says, and indicated that Grutter was different because in these new cases, the policies actually rely on what it called negative stereotyping. So again, sort of pre-assuming that all individuals of a given minority group think or feel a certain way. That in this case, the policies had what the court believed was a discernible negative effect on Asian American applicants. And then finally, the court appeared extremely persuaded by the fact that, according to the universities, there was no clear, discernible, logical endpoint to the policies. Again, I'll go back to the language in Grutter where Justice O'Connor indicated her belief that 25 years, from now, there would be no need for these policies. Of course, we're not quite at the 25-year mark, but we're close. And the majority seemed persuaded by the fact that even though here we are in 2023, we're still relying on these policies, and found that ran counter to Grutter. So what is and what isn't allowed then in educational admissions as a result of the decision? The answer is sort of simultaneously very clear and in other ways not clear at all. So there are certain things that are definite no-goes now. No adding points to an applicant's score based on race. No consideration of a prior class year's demographics in making application decisions. In other words, trying to ensure that your minority statistics stay stable over time. No consideration of a class's sort of total racial makeup as a whole, at least no overt consideration. And no pulling waitlisted applicants specifically because of their race. But interestingly, the court, it did leave open, and in fact suggested that educational institutions can still consider the impact of an applicant's race on his or her life experiences, qualities, personality, that sort of thing in making a decision. So long as the court cautioned the decision is made on the quality of character or unique ability that the particular candidate can contribute to the university, and not on race for race sakes, we'll call it. Of course, this sort of opens up a big gray area if an applicant in, say, an admissions essay discusses the impact of race. Who's to say whether a decision made on the basis of that essay was made on the impact of the individual's race as stated in the essay, or on race itself. And I think we don't have a crystal ball, but if we're looking ahead, I expect we will see continued litigation over these types of sort of softer considerations of race that at least now the court has held are lawful. And before we, move into the sort of the next meaty part of our time together, again, I'll be clear that this decision specifically deals in the education context, right? And even more broadly, it deals with the Equal Protection Clause, which applies to state actors and organizations, companies that receive state funding and as a result are acting as state actors. It doesn't apply to fully private actors. But as we'll spend the rest of our time today exploring, we think that this decision is really primed and ready to have a significant impact and really will impact sort of consciously or unconsciously courts' decisions of DE&I efforts, of discrimination in other contexts such as employment, contracting, that sort of thing, even though these private employers and entities are not specifically covered by the 14th Amendment.
Thank you, MC. We're going to switch gears now. But before we do, I want to highlight something MC's been wrapping up. And this comes as a shock to a lot of Americans to know that in the purely private sector, employees in the employee-employer relationship generally don't have constitutional rights under the U.S. Constitution. It only applies to state actors. So the question becomes, well, I'm not an educational institution. I'm not in the public sector. What does this case mean for me, and where are we going? And for that, I turn it over to Dan Kaplan, who's going to answer some of those questions.
Thanks, Mark. Nice job, MC. First and foremost, I think for all of us to understand and appreciate the impact of SFFA on our private employment occurrences or businesses and other things, we need to understand what the law is that is applicable to private employers. As Mark noted, the Constitution and its amendments do not generally apply to private businesses in the workplace. But there are 3 laws that do have application to private employers. 2 of them absolutely have application, and 1 has application to federal contractors. First, we have to understand that Title VII of the Civil Rights Act of 1964 and Section 1981 of the Civil Rights Act of 1866 both apply to private employers, businesses that employ others. Executive Order 11246 is an executive order that came out with Lyndon Johnson, and that applies to federal contractors. We need to appreciate and understand those laws, and I'm going to talk about each in a moment. Second, we also have to appreciate the Great Reckoning following the George Floyd incident, and that incident did not, in and of itself, change the law. The law under Title VII, Section 1981, and Executive Order 11246 is the same today as it was pre-pandemic, and it's the same today as it was pre-SFFA. And third, we want to engage in DEI efforts without running afoul of the law. That's not anything that has changed because of SFFA, but we need to understand why it hasn't changed at all. So first, what does Title VII prohibit or permit? First off, Title VII of the Civil Rights Act of 1964 makes it illegal to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual with respect to that individual's compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin. The bottom line message from Title VII is that protected traits are not relevant to the selection, evaluation, or compensation of our employees. Title VII does not prohibit efforts to improve diversity in the workplace. And as EEOC Chair Charlotte Brown noted, following SFFA's release, it remains lawful for employers to implement diversity, equity, inclusion, and accessibility programs that seek to ensure workers of all backgrounds are afforded equal opportunity in the workplace. Section 1981 is a Civil War era piece of legislation. It was amended in 1991, but the original legislation came out around the Civil War, right after, and it required the equal treatment of all citizens. So when it was first passed, it provided that all citizens, all persons within the jurisdiction of the United States shall have the same right in every state and territory to make and enforce contracts. That term, contracts, becomes very important later on in our jurisprudence. To sue, be parties, give evidence, and to the full and equal benefit of all laws and proceedings for the security of persons and property as is enjoyed by white citizens, and shall be subject to like punishment, pains, penalties, taxes, licenses, etc. I think it's important to note, right, when Section 1981 came out, in 1866, it included as is enjoyed by white citizens. The intent was to create equality of opportunity in the economic realm of our country for everybody to be treated as white citizens were being treated at the time. So you hear a lot, especially with this Supreme Court, about going back to strict construction, right? And looking at the actual language and what the authors of legislation or the Constitution meant at the time that they passed it. Well, the language that was included in 1981 at the time was as enjoyed by white persons. So it was clearly intended for the benefit of persons who were not white. As you're going to hear from Sarah later on, a lot of litigation that's coming now is actually turning on its head. It is the opposite of what was initially intended. And that's because in 1991, Section 1981 was modified and amended. And that amendment deleted, actually, it's still there, but it's not treated with as much application or strength, the term white citizens. And let's talk briefly about Executive Order 11246. So anybody who's on this call who is a federal contractor or subcontractor should recognize that they have additional obligations beyond Title VII, beyond Section 1981. And those obligations come to us by virtue of an executive order that was signed by Lyndon Johnson back in the 60s. And that said, listen, if you're a federal contractor and you want the right to do work or contract with the federal government, then you have to apply by certain affirmative action obligations. It's important to recognize that those affirmative action obligations under Executive Order 11246 do not permit nor require a violation of Title VII or Section 1981. What it does require is for the contractor to identify by job group within its employees goals to improve diversity in that workplace. The goals are supposed to be identified based on employing persons and where those employed persons come from. The overall goal of an affirmative action plan is to get your employees, your workforce, to mirror the communities from where the hiring is occurring. So if the community is 25% Black, your employees should appear to be 25% Black, right? That's the goal. And if you don't meet those goals are numerical, by the way, right? Executive Order 11246 says, I want a specific goal identified so we can show what it is that we're aiming for. But be careful, because even if you're a federal contractor or a subcontractor, goals are not synonymous with quotas. And what the OFCCP wants, the Office of Federal Contract and Compliance Programs, which is the Department of Labor agency required to enforce Executive Order 11246, is they want to see you improving feeder groups or improving applicant pools, not making decisions based upon race. So, bottom line, are DEI efforts still legal or what? What did it should be SFFA do? SFFA did not make DEI efforts illegal. Rather, the new decision is just a stark reminder that the law is the law, and while there may have been very limited instances, those with respect to educational institutions receiving funding from the US government, that are no longer applicable, those plus okays that used to exist, there is no plus factor allowed ever in the private employment realm, right? Title VII doesn't allow a plus factor. Section 1981 does not allow a plus factor and never has, and neither does Executive Order 11246. So if you had a compliant DEI program before SFFA, you should have a compliant program after SFFA was decided. But it's definitely a wake-up call, right? For all of us that have diversity, equity, and inclusion programs, or diversity, equity, inclusion, and belonging programs, we ought to review those programs and ensure that they are compliant, because what you're going to hear from Sarah is going to scare the living you-know-what out of you, because there's a lot of litigation that is now being premised on this new decision. So what can we expect in the future? Bottom line, the law is the law. So long as your DEI efforts were created in a manner that does not run afoul of Title VII or Section 1981, your DEI efforts should still be legal. The only way that would change is if Congress modified Title VII to require or to prohibit certain DEI efforts. Again, this only makes sense, right? The goal of Title VII was to eliminate reliance on immutable characteristics for employment-based decision-making. We're at the same place today as we were a year ago. And just like federal contractors under Executive Order 11246, the key to compliance will be a focus on creating opportunities, right? Not actual decision-making that are based on immutable characteristics.
Dan, before we transition, a couple of questions. Is there a difference in the burden of proof between bringing an action under Title VII versus 42 USC 1981? And can you explain that?
Yeah, it's a great question. I mean, there is a difference, right? Section 1981 requires proof of intentional discrimination, whereas Title VII Title VII actions can be premised upon either intentional discrimination or a disparate impact. So if you have a policy that is not intentionally designed to discriminate against somebody based on an immutable characteristic, but that is the impact it is occasioning, then that can run afoul of Title VII. Whereas for 1981, you have to show intentional discrimination.
And one last one before we switch. The executive order was issued in 1964, 59 years ago. What litigation has been brought to challenge its constitutionality?
So there are pieces of litigation that are out there now. Most of the litigation has been premised on how far abroad, right? When is it that somebody becomes a federal contractor or subcontractor? So for example, we had a number of pieces of litigation to determine whether or not hospitals are federal contractors based on acceptance of Medicaid or Medicare and things of that nature. We have not seen a lawsuit, to my knowledge, and there may be some that have recently been filed, but not seen to my knowledge, that have actually challenged the presidential right to issue an executive order such as 11246. Because remember, that executive order is in place because you, private employers, are choosing to do business with the federal government. You're not being forced to do business. But if you want access to those 500 billions and more dollars that are at stake from federal contracting, you're going to have to comply with certain rules and requirements, and Executive Order 11246 is one of those.
Thanks, Dan. We're going to turn it over to Sarah now. In addition to being an amazing litigator, she has great clairvoyant abilities and is able to look into the future, and she's going to tell us what she sees.
Thanks, Mark. As much as I appreciate all of the praise, I'm not sure that I would go that far, but I do hope that I can give you a little bit of the landscape of the kind of litigation that we are seeing from private plaintiffs. This litigation, there's really two main statutes, as we said, that people are litigating under. Their Title VII claims and their 1981 claims. These lawsuits are not necessarily new. However, since SFFA, there have been a number of 1981 claims filed that we'll talk about today. So there are a few types of lawsuits that, as I said, we've seen. The first type of lawsuit are lawsuits challenging diversity targets and associated compensation and promotion decisions. Are diversity targets simply aspirational, or are they in fact tied to compensation or promotion decisions in an unlawful way? And we'll be talking about and we'll be talking about that case first after this slide. Next, lawsuits challenging economic bonuses provided only to certain underrepresented groups. We'll be talking about a Comcast case and a case against Amazon that falls under this category. These are claims where the plaintiffs are claiming under 1981. Lawsuits challenging fellowships and scholarships that are restricted to certain underrepresented groups. So, plaintiffs are bringing cases saying you can't restrict the ability of certain other groups to contract. And so therefore is a scholarship that is limited to certain underrepresented groups, in fact, unlawful. And then, challenging resources, opportunities, or trainings provided to certain underrepresented groups through affinity groups or the like. While I won't highlight any cases that really go to this point today, I think there is, again, an open question as to what comes next. So the first case we're going to talk about is Broken Hill Proprietary. Broken Hill Proprietary, as I said, is a Title VII case where the plaintiff alleged that his employer, who had announced an initiative to have 50% of its workforce be female by 2025, unlawfully discriminated against him by denying him promotions as well as compensation because of its goal to balance the workforce and promote or compensate promote women over men, or to tie the compensation of the decision makers to whether or not they were furthering the company's goal of achieving the 50% women in the workforce. This case went on and actually went to summary judgment. Both sides submitted evidence. Some of the evidence that was submitted by the plaintiff was testimony by managers who said that, in fact, they were receiving pressure to put women into new roles. Of course, the company provided evidence on the other side that, in fact, their goals were just aspirational, that, in fact, bonuses and promotion decisions weren't at all tied to their goals of having 50% of the workforce female. At the end of the day, though, the court held that there was a factual dispute as to whether BHP's gender balance goal, including its tie to the performance evaluation and bonuses of those making the hiring and promotion decisions at issue, amounted to unlawful affirmative action, unlawful affirmative action plan that adversely affected Power's employment. To the extent that your company does have goals of certain percentages or otherwise, I think it is informative and useful to read the summary judgment decision, because in fact, I think it does give you a roadmap to some of the factors that the court considered and how the court might look at your program. And of course, like Dan said, if you have a question about what your DE&I program, reach out before, of course, you become the target of one of these lawsuits for counseling as to whether the program would likely be lawful or unlawful. All right, Boulder v. Amazon. So in this case, the plaintiff alleged a claim under 42 USC 1981. And here, Amazon partners with delivery service partners. So delivery service partners are responsible for hiring, training, and maintaining a team of drivers and delivery vans to deliver Amazon packages. As part of this program, there was a diversity grant program. So for delivery service partners who were minority owned, they could apply for a $10,000 bonus that could help them with their startup costs. The plaintiff here was a white woman who said she was excluded from being allowed to apply for the bonus, and therefore the Amazon's policies were unlawfully restricting her from entering into the contract to receive this bonus. The Amazon did make a motion to dismiss here. This case really raised, and in their motion to dismiss, they raised, I think, two of the issues that really are issues that everyone is wondering about with these cases. And the first is whether, in fact, this plaintiff even had standing. In the pleadings, she stated that she would have applied or started to apply for the program, but didn't fully apply for the program. So was there, in fact, does she in fact have standing? Was there any immediate or actual injury here? And then two, Amazon argued that, in fact, she failed to state a claim because she hadn't even qualified to be a delivery service partner. So as she wasn't even a delivery service partner, race couldn't have been a factor that prevented her from actually getting the $10,000 diversity grant. She wouldn't have been eligible for it in the first place. She had to first become a delivery service partner, which was a race-neutral selection process. And then after becoming the delivery service partner, she would have had to qualify for the diversity grant. But I think the standing issue is a live issue. It's an issue that we'll circle back to as we go through some of the later cases. Who has standing to bring these claims? And do the plaintiffs who are bringing these claims actually have standing if they didn't actually apply for the program that they're complaining about? Next, we have Moses v. Comcast. Here, Comcast offered a program called Comcast Rise, which was an opportunity for minority-owned businesses to receive funding and resources to elevate their small businesses. The program was limited to certain underrepresented groups. Again, the plaintiffs here were white business owners who felt that they were unlawfully excluded from the program under 42 USC 1981. Here, Comcast again made a motion to dismiss, and in their motion to dismiss, they really raised the second issue that I think a lot of us are thinking about is, can a company make charitable contributions or the like to whoever it wants in furtherance of the goals or missions of that company or that program? Here in its motion to dismiss, Comcast argued that 1981 simply doesn't apply to the type of charitable grant which this program constituted. They said this kind of program where Comcast is trying to provide resources to a group of business owners, minority small business owners who were disproportionately affected by COVID, is not the kind of charitable grant program that should be covered by 1981. They also raised the issue of whether there really is a contract here. As Dan said, 1981 is really about everyone being allowed to contract regardless of their race. Here, Comcast argues there is no real contract. While Comcast does have the applicants sign an agreement that Comcast will be able to use their likeness or otherwise, they're saying they're not really getting anything back. And so therefore, this isn't really the kind of contract that's contemplated under 1981. I think that that's going to really be another live question going forward. What constitutes a contract for the purposes of 1981? And in this context, where it seems clear that the aim of whatever grant is given is charitable, can a plaintiff bring a claim under 1981? Then finally, there are two cases that were just recently filed against law firms relating to diversity fellowship programs. Diversity fellowship programs, which were provided. So diversity fellowship programs in these cases were aimed at providing a monetary bonus to applicants to the summer associate programs at these law firms, that they would be paid an amount above and beyond what they would otherwise be paid for their summer internships. In both of these cases, the applicants were restricted to, or alleged to be restricted to, underrepresented minorities, those who are part of the LGBTQ community, and disabled applicants. Again, the white male plaintiffs alleged that they were otherwise more than qualified for the diversity fellowship and were only excluded on the basis of their race, and that was unlawful. I think that there is, again, a real question here as to whether the plaintiffs have standing, and it's likely to be an issue that is raised going forward in the case, as the pleadings show that or state that the plaintiffs didn't in fact apply for the fellowships, but that they didn't apply because they knew they would be unlawfully discriminated against. So again, was there any actual or imminent injury here that would allow them standing to bring these claims? Overall, I would say, there are more questions than there are answers. As I said, the first case, there is a summary judgment decision that you might be able to read to get some guidance as to how the court is thinking on these issues. But in all of the other cases, the parties did settle before there was a determination on those motions to dismiss issues that I mentioned. And so we really don't know where the court would come out on them, although the papers, again, are instructive to see how the parties are thinking about these issues and some of the issues that might come up if your company were to have to defend one of these cases.
I'm going to throw this one out to the group. Maybe Sarah, you want to go first. What about a private entity trying to mimic what the government has done through contracting? For example, I'm a private equity firm and I dole money out and I want to encourage diversity in the business community. So I target some of that funding to minority-owned businesses, much as the way the government does when it issues construction grants and other types of things, which are known as minority set-asides. In the construction industry, they have the same thing for female enterprises. What do you think about that in light of the recent decision?
Look, Mark, I think that program could be open to challenge. Like I said, a lot of these plaintiffs are coming after corporations or companies under 1981. At the same time, I think it's all about making sure that you're, advertising whatever program it is to a diverse group of applicants, so that you have as diverse a group of applicants as you can, rather than necessarily restricting the applicant pool by any characteristic, and considering the applications as you get them, but really aiming toward your efforts towards advertising and promoting those programs to as diverse a group of applicants as possible.
Dan, what do you think in light of your expertise in 11246 matters?
I agree. I think Sarah's spot on. I think what should be done, right, is if you're focused on Title VII, if it relates to employment, you're going to be more focused on Title VII, although Section 1981 also has application. But you're looking at expanding opportunities, right? So if your workplace suffers from a lack of minority representation, maybe try and do some job fairs at historically Black colleges or universities. So the goal in reaching out and expanding the applicant pool, that's never going to run afoul of Title VII, right? You're just opening up opportunities that way. Still can't make decisions, but I think it opens it up. I think with respect to, the issues about ventures and the things that Sarah was also just talking about a moment ago, 1981, as we know, deals with making and enforcing contracts. And I think if you want, we're going to talk a little bit about what we should be doing and these takeaways. And I think one thing you want to be doing, if that's your focus area, is make sure that you're not creating a contract, right? This is the fertile ground where all the litigation is taking place. So if you want to provide a charitable award or something of that nature, don't have potential recipients sign off on their copyright rights to the product that they're submitting. Don't have them sign off on allowing you to use their likenesses or otherwise, right? If you eliminate those kinds of signatures, you're likely eliminating a lot of the contracts under which 1981 can be based.
And as it's sort of been mentioned, but to bring it home, don't tell a protected group of people they can't apply or they can't participate. Once you do that, you do set yourself up for the plaintiff, who is the excluded person, because they couldn't participate. They weren't allowed to get this, be it a business opportunity, scholarship funding, or a job. MC, what about voluntary affirmative action programs? So I'm a social service agency or a healthcare for-profit healthcare organization with a very targeted customer or patient clientele. And I believe in order to be effective in delivering our services, my workforce needs to mirror my customer or patient population. And right now it doesn't. So I want to fix that. What about that? You're muted.
Sorry, everyone. I'll echo what Dan just said. A focus on expanding your applicant pool and on even sort of targeting your applicant pool specifically to fill a need is critical, right? And the hope is that by doing that, things will sort of trickle down in a way that's achieving that goal. You know, there's also sort of an interesting line in some of these cases between the interaction between and distinction between race and national origin. Courts have held that making decisions based on national origin, if there's some sort of bona fide occupational reason for doing so, may be permissible, while it's not permissible to do so for race, right? So depending on the fact pattern, I can see an instance where you're framing the sort of hiring through the national origin lens and not through a race lens. But that's definitely sort of murky waters, especially in 2023 now with this line of decisions. So focus on the pool expansion. That's key. Get creative, you know, don't just sort of pursue the same old channels you've been pursuing to hire if those channels are not yielding the employee base that you want.
Follow up, MC. So I'm not going to set specific goals and timetables. I'm going to do outreach, but can I monitor my activity, do statistical analysis to see if I'm making progress to reach this goal of mirroring my customer or patient population?
That's right. You know, there's certainly nothing wrong with tracking information, you know, that's useful for a host of information or for a host of reasons. So having that information, monitoring the trends over time is fine. And unless you're falling into those sort of impermissible quotas that we've talked about. And, you know, if you're not falling into those sort of telltale negative buckets that will set you up to be the low-hanging fruit, then keeping track of the data is fine.
So how about another twist? Many for-profit companies have separate charitable organizations that they use to provide charity or community service, do grants, scholarships, all types of things, as well as 501c3 tax-exempt charities who have specific missions and goals in furtherance. What if I start doling out money, scholarships, let's use as an example, but I don't tie it to getting a job? I want to just give a scholarship to a well-deserving minority person to study computer science or some other industry where there's lower representation. What about that?
Yeah, I think as a plaintiff, the issue someone would run into is has there been a contract, right? Like what is the grounds to sue in that case? And as a defense attorney, that would certainly be our first argument. Again, going back to a point that, that Sarah and Dan have made, that just don't ask them to sign something. Don't say we're entering into a contract, right? Don't attach potentially problematic language that could make your otherwise permissible gift permissible. I do think, and this is the truth, we're all sort of walking this road together. I think that this area of law is growing and changing, and we'll all be monitoring it closely. And of course, we'll let all of you know as these cases sort of come to fruition. I think that could be a tough one for a plaintiff to ultimately prevail on, but I also don't think that will stop plaintiffs from bringing the claim, right? I think that there's still risk there.
Mark, I think MC is exactly right. And I think that the Moses v. Comcast case would be helpful and instructive to read if you are considering a program like that. And again, these plaintiffs are not shy. They are bringing these lawsuits. And so if you are considering a program that you think could be questionable, it is really the right time to get outside counsel or someone else to consult with you about whether or not the program that you're putting in place is going to make you a target. And if you are, if you are the target of a demand letter or otherwise a lawsuit, as you can see, a lot of these lawsuits have not yet really gotten to these ultimate issues, or there's been no decision on these ultimate issues. And so, no company wants to be the test case for these lawsuits. Again, it's really the time to make sure that you are getting the best advice and the advice that you need in the face of even a demand letter or of course a lawsuit.
And I'm going to add here too, I think, both Sarah and MC are spot on. If there was one thing, right, I would say SFFA did not change the law unless you're an educational institution. But what it did do is wake up some sleeping giants and redirect attention and focus. And so I think it's incumbent upon all businesses to really, before you implement a program, talk to the experts who have some experience in this space about a program's design. And it's any sort of a compensatory or a benefit related program, right? Whether it be a scholarship being offered to the public in general, or whether it be an incentive compensation program being offered to executives at a publicly traded business or not. Look at those programs now, right? The lawsuits that we're seeing on the latter side, right, the incentive comp programs, are because the program identifies a specific number to be reached. And that if that number is not reached, you don't gain access to that pool of money for incentive compensation. That is just not where your program needs to go, right? Your program needs to take a different tact, and you should have those programs reviewed before you implement one of these programs. And to answer a specific question that you raised a little bit earlier is, does it matter if you're a 501c3 or not? Bottom line is, Title VII applies to 501c3s. Section 1981 applies to 501c3s. So unless there is a specific exception, you still have to comply with the requirements of Title VII and Section 1981.
What if I follow MC's advice and I do an internal statistical analysis, I engage in outreach? Next year, I want to see how I did. My results look terrible because I wasn't very successful in my outreach efforts. What are the problems? Can that be used against me in other litigation?
Yeah, I think it can, right? I think anytime you undertake any kind of studies, any kind of reviews, you get a savvy, creative plaintiff, and they're going to ask for that sort of information in discovery, right? But that information in and of itself is not evidence of discrimination. If you take that information and then make employment or other decisions based on race, based on an immutable characteristic, that's the evidence that plaintiffs are going to look at. But if you want to be you want to be a little more safe, I think Sarah, MC, and I would all recommend engaging counsel to assist you in those kinds of reviews. Now, it may not be an attorney-client work product or privileged communication because it may not be in anticipation of specific litigation, but at least it gives you an argument to try and protect that from discovery later on.
And, you know, you have a bullet up on the slide. You want to admit to a past practice of discrimination. Can you elaborate a little bit? It's kind of related to what you're touching on here. Give us some do's and don'ts.
Yeah, so there is an exception, right? Under Title VII and Section 1981. And it was the exception that MC talked about, right, when she was referring to Bakke. If you have historical discrimination that you're trying to correct or right, you can use that as a basis for employment-related decision-making or otherwise. But in order to use that, you're going to have to show that you were a historical discriminator. And I'm not aware of many companies that want to do that.
I wouldn't think so either. We're going to wrap it up in a few minutes. So again, last chance, get your questions in through the chat. I just ask each of you, starting with Sarah, give us a takeaway.
I think the takeaway that I think is important here is when we were talking about charitable grant programs, it doesn't mean that you can't have a charitable grant program that targets certain underrepresented or diverse groups, but you need to think carefully about whether you're entering into a contract with the person or people that you're giving the grants to. Is there a way to mitigate risk there by not asking to be for any type of ability to use their likeness or otherwise, and therefore avoiding, hopefully, a potential claim from a plaintiff under 1981.
Dan, your takeaway?
My takeaway is, DE&I is important. I think a lot of customers, clients, and individuals appreciate a fulsome opportunity to get impressions, ideas from different perspectives. That's one of the goals of DE&I, right? And I don't think any employer should be scared away from maintaining and continuing a DE&I program based on the decision of SFFA. Those programs were legal before. Those programs are legal now. You just have to do them right.
And the final word from MC, who's going to remember to unmute her mic.
That I will. I think to piggyback a little bit off of Dan's point, I would say semantics matter a lot in this space. How you're describing what you're doing matters. It's of ultimate that's sort of the utmost tantamount here, because you may have extremely sort of noble aims of increasing diversity in your workforce, but at the same time, you're not overtly making employment decisions on the basis of race, right? That's always been unlawful. You're going to continue to follow that. So just be sure that in whatever document, policy document, whatever you're using to describe any of your DE&I efforts, you're not misstating them, right? You're not mischaracterizing them as something that's both unlawful and also truly probably not the spirit of your program to begin with.
And with that, it's a wrap. We're out of time. We're at 2 minutes after. Thank you all for attending.